Hello everyone, my name is Muskaan and today we'll be talking about the types of damages under Section 73 of the Indian Contract Act 1872. So we'll talk about what a contract is and then we'll look at the general and specific types of damages under Section 73 of the Act. Now the Indian Contract Act of 1872 it deals with the regulation of all the contracts that are made in India and even foreign contracts. So it came into force in September of 1872 and it is applicable throughout the entire territory of India except for the state of Jammu and Kashmir. So in order to understand any of the laws governing contracts, we first have to understand what is a contract, what is the definition of a contract, or what is the meaning of a contract. So any and all laws that govern contracts in India refer back to Section 2 of this particular act of the Indian Contract Act, which is the interpretation clause. So because these definitions are interconnected, that's why I have not gone in order when we look at them. We'll try to understand what each of them means and we'll look at other sections whenever new terms crop up. Okay. So first, Section 2H states that a contract is an agreement enforceable by the law. So now this is clear. This is pretty straightforward, but we need to know what an agreement is to understand this definition. So Section 2E gives us the answer to that. An agreement is every promise and every set of promises that form the consideration for each other. Again, we have two new terms here. One is a promise and one is consideration. So let's look at what promise means. Under Section 2B, a promise is a proposal that is assented to by the person to whom it is made. Now, a proposal basically means that I'm proposing something to you. So, for example, if I say, I would like to sell you my bike for X amount of money, that is a proposal that I'm making. Now, if you accept the proposal, then it becomes a promise from my side. If you say, yes, I'm ready to buy your bike for X amount of money, that becomes a promise, right? Now that you've assented to it, it's a promise from my side to give it to you. So two other important terms here are promisor and promisee. So the person who is making the proposal is the promisor and the person who is accepting the proposal is the promisee. From now on, these are the terms we're going to use when we refer to either of those parties. All right, so we saw that a promise is a proposal that is accepted by the promisee, right? And the promisee is the one to whom you're making the proposal. Now, what is a proposal? Like the example I gave you, when one person signifies to another his willingness to do or to abstain from doing anything with the view to obtaining the assent of that other to such act or abstinence. Now, I already gave you an example for willingness to do, my willingness to sell you my bike. Now, abstain from doing anything can also be a promise. So if I say, I will promise not to hold my dance classes in my flat if you pay 1/4 of the amount it takes for me to rent out a different place to hold the classes. That is a willingness to abstain from doing anything. And the other word we saw was consideration. This is given under Section 2D of the Act, and it says that when, at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something. That is called a consideration. So in all of my examples, say the money that I'm asking for in return to give you my bike, or the money I'm asking for in return to stop hosting my dance classes in my apartment. That is called the consideration. And now the consideration can move from either one of the parties depending on whether it's a unilateral contract or a bilateral contract. And this definition of consideration also makes sure to include past, present, and future considerations. So all of this will be covered in a separate video. For now, let's focus on damages itself. Okay, so before we move on to damages, let's just wrap up the meaning of contracts. So we know that contract is an agreement enforceable by law. We know that an agreement involves a promise and it involves consideration. And we know that promise involves a proposal which is accepted. So now we come to the enforceable part. So Section 10 of the Act lays down the essential elements of a contract. So without these elements, a contract will not be seen as valid in the eyes of the law. So the first one is the consent of the parties, but it's not just mere consent. It has to be free consent of the parties. Because if either of the parties involved are coerced or manipulated or threatened or blackmailed into it, then there's no free consent. So there has to be free consent of the parties. Second, the parties must be competent to a contract. This means they must be of sound mind, they must be over the age of 18, and they must not be insolvent. So these are all the things that make a party competent to contract. Third, we know that consideration is important, but it's also important for there to be lawful consideration. And similarly, there also has to be a lawful object. So the object of the promise and the consideration of the promise both have to be lawful in the eyes of the law. You can't use gambling, you can't use murder, you can't use theft either as an object or as consideration. And finally, uh, as long as the contract will be considered to be valid as long as it's not expressly declared to be void. So all contracts are valid if they follow these 5 items, otherwise they're considered not valid. Alright, so let's now take a look at what are damages. So there's one major thing that we have to look at. First, what is the meaning of the term damage and what is the meaning of the term damages? Now, in normal English, you would say damages is the plural form of damage. But when it comes to legalese or legal language, these two things, although related, they have slightly different meanings. So the damage is considered as the cause, okay, and the damages is considered as the effect. Look at it in terms of cause and effect. So especially in contracts or any civil offenses, civil wrongs, when any loss or injury is caused to either of the parties, that is termed as a damage caused to the parties, right? That's the cause. So, and the damages is the amount of compensation that the party is entitled to receive. So the cause is the loss of the injury and the effect that they will get compensated for that loss or injury. So when any person suffers a damage due to the actions of another person, then they're entitled to claim damages from the other. And in this particular video, we're going to be talking about the different types of damages. Alright, so now let's look at section 73 of the Act. Now, section 73 specifically talks about the compensation for the loss or damage that is caused by a breach of contract. So it talks about what are the damages you can award to the party that has suffered from some loss or injury. So there are 3 particular circumstances that are directly mentioned under section 73. The first one is if the loss or damage is caused by the breach naturally arose in the usual course of the events. So if whatever contract that you have made, if the other person does not comply with or breaches the basic obligations of the contract, leading to direct damages or damage or losses that are caused, then that is one of the things that you can get damages for. The second one is if the parties knew at the time of making the contract that such loss or damage will result from the breach of the contract. So if in the contract itself the parties have specifically mentioned in a clause that if this is not complied with within this amount of time, is like, say for example, it's a time sensitive contract and I have informed you that it's a time sensitive contract and I need you to do this particular thing within this particular time. If you have not done it within that time, then that is, the parties would have known at the time of making the contract that if you did not comply with the time, then it would not have that I would suffer some loss. And thirdly, if there has been a failure to discharge any obligations that resembles the obligations created by the contract. So it's not necessary in a contract that you list down each and every possibility that you can think of. If there is anything that you might have missed but which resembles whatever you've written down so far, then that will also be considered a breach of contract and you are entitled to claim damages from it. Now these 3 in scope are pretty wide. So when we look at the different types of damages, we will see that several of those types can fall under either one or the other of these 3 particular things. So section 73 only mentions these 3 types of damages that you can claim. And the explanation for the section that also states that at the time of estimating the loss or damage suffered, the existing means of remedying the loss or damage caused by the breach must also be considered. So here I've used damages in the normal English context. Please don't confuse. Don't get confused. What I mean is any injury that is caused here, then the existing means of remedying that injury caused by the breach must also be considered to award the damages, the compensation. So this, I don't think I need to explain this. Basically, you just have to take into account whether there is some other means of giving them or remedying the loss or damage that is caused without paying them actual damages. So, okay, so now let's talk about the different types of damages. So on and on, it can be divided into two broad categories. One is liquidated damages, one is unliquidated damages. So what does that mean? Liquidated basically means that you have a fixed amount for the breach. So if I've written down in the contract that if you breach the contract, you will pay this particular amount, you will pay double the amount of the original money that was put in the contract. That's a fixed amount for the breach. So when you go to the court might think about giving extra damages, but most of the time they'll just award the aggrieved party the fixed amount for the breach. The second one is unliquidated damages. It's exactly the opposite of liquidated. There is no prior fixed amount that has been decided between the parties. So it is up to the courts to calculate how much damages should be awarded. So there are 6 different types over here. The first one is general, which is covered under the first type under section 73, which talks about injuries that are naturally arose in the normal course of events. So that doesn't need to be explained anymore, I guess. The second one is special. So when the parties agree to compensate some particular kind of loss, like the second point mentioned in the section 73, where if you in the contract itself you guys mention you both the parties involved write down that this particular thing is going to be compensated, that becomes special damages. Then you have nominal damages. So nominal means that you can't actually prove that any actual loss or injury or damage has been caused, but you can prove that there is a breach, there has been a breach of contract. Maybe the breach of contract didn't actually affect you. So however, it's still a civil wrong, right? So the party still has to be punished in some way, or there should still be some compensation given. Otherwise, people will do it left and right. So for that reason, nominal damages are awarded simply for violation of the legal right. So this is some small nominal amount just to give some compensation to the party for their legal right being breached. Then you have substantial damages. So this is over and above the general or the special damages. If in the course of the events there has been some special or substantial extra damages that you have suffered because of the breach of contract, and that such damages you may not be able to calculate exactly how much it is. So in that case, the court will take into account approximately how much loss you may have had, and you can recover those estimated costs. Then there is aggravated damages. So aggravated damages are given for mental distress, and a lot of times if you have interned somewhere or if you have seen documents, they write that this person has suffered this great emotional distress and all that stuff. So for that, you can actually ask for some certain amount of compensation. And then you have exemplary damages. So this is entirely dependent on the court. So the rest of the damages are solely to compensate the aggrieved party. But the court might say that, we need to punish the party. That it's a sort of punitive damages given over and above the compensatory damages. So general damages do not need to be specifically pleaded because they arise in the general course of the contract. You prove the breach of the contract, you prove a certain general, like this happened because of breach of contract, so I am entitled to that money and you will get it. But for special damages, substantial damages, aggravated damages, you have to specifically go to court and prove that this is the extra damages that has occurred and I should be compensated for that as well. So these are the types of damages. All right, so in order to understand damages, let's look at some illustrations. All of these illustrations I have taken from under section 73 of the Act itself. So if you want to read the others, you can go ahead and do that. Uh, the first one, we'll look at a simple contract between two people, A and B, where A is buying B's ship for 60,000 rupees. However, A breaks his promise. So now there is no special stuff that have been mentioned in the contract. It's a simple contract to buy things. On top of that, there is no other consequences that B is facing besides the fact that his ship is not being bought. So A must pay to B by way of compensation the excess, if any, of the contract price over the price which B can obtain for the ship at the time of breach of promise. So once A has breached the promise, B can easily find somebody else to sell it to. But say that person refuses to give 60,000 and they say that will only give you 50,000 or 40,000. So the difference between the original contract that he had with A and the amount that they are ready to give B, that is the money that A has to pay. So this is a breach that arose due to general course of events. So this is general damages. Next one, A has a contract with B where B is supplying A with iron to be delivered at a stated time. Then A is also contracting with C for purchasing iron at a certain amount, which is less than the amount that he's selling it to for B. And he tells C that he is doing this contract with C only for the purpose of performing his contract with B. So C is aware that if he doesn't give the iron to A in time, then A cannot give the iron to B and A will face losses. So C fails to perform his contract with A, who is unable to procure other iron, and B then rescinds the contract. So now A is losing out his contract with B. Now, because A and C have already specifically mentioned that A is doing this to sell it to B, and if he doesn't, then he will, if C doesn't sell to A, then he will face loss. That is why C has to pay to A 20,000 rupees, being the profit which A would have made by the performance of his contract with B. So, besides the general damages which he might have to pay, A also has to pay this extra amount of money. So, these are what is called as special damages. Then A contracts to sell and deliver cotton to B on a fixed day. A knows nothing of B's mode of conducting his business. So B has not given any information to A as to why he needs this cotton on this particular day. So A breaks his promise and B, having no cotton, is obliged to close his cotton mill. Now it turns out B had a cotton mill and he needed cotton to run that mill. However, since he had never informed A of this, then he can only B can only get the nominal damages or the general damages from A. But A is not responsible to B for the loss caused to B by the closing of the mill. So this is what is known as nominal damages. There doesn't seem to be any general damages because there's no particular sale that B is losing out on. There is, and A and B had no idea of anything extra. So there's no special damages. So in this case, B is only going to get nominal damages. Next one, A contracts to repair B's house in a certain manner and receives payment in advance. So the payment has already been made. Then A repairs the house but not according to the contract. So the house is repaired and it may even have been repaired well, but it hasn't been done according to the contract. So there is already a general, there might not be a general damage because, nothing has happened in the direct course. If he had not repaired the house, then the general damages would have come in general course of events, right? Then there is no special damages because they have specifically mentioned according to the contract. So there must be some special damages. You can say special damages, but here something else comes into account. Because what we're talking about is that B is entitled to recover from A the cost of making the repairs to conform to the contract. So he will receive his general damages and his special damages. But besides that, he will also receive substantial damages, which is the extra money that he is now paying to make sure that the repairs conform to the original contract. So that is what is known as substantial damages. And in order to understand general, special and substantial, we're going to look at one final example. So A builder, contracts to erect and finish a house by the 1st of Jan so that B can give possession of it to C. So A and B have a contract, B and C has a contract. And A knows about this contract between B and C. So obviously, if A doesn't finish the building in time, or if he does it badly, then B will not be able to give to C by the 1st of Jan, and B will lose out. A builds the house so badly that before the 1st of January, it falls down and has to be rebuilt by B. So in that consequence, he loses the rent which he would have gotten from C if C had shifted in. And on top of that, he is also obliged to make compensation to C for the breach of the contract with C. So in this case, you will see all the three different types: general, special, and substantial. A must make compensation to B for the cost of rebuilding the house, for the rent lost, and for the compensation made to C. So what arises from general course of events? The cost of rebuilding the house, because he made it so badly that it fell and he had to rebuild it. Then the rent that is being lost, he had specifically told A that I need this to be done, otherwise I'm losing out this much money. So that is the special damages, the rent lost. And finally, over and above these two, there's also the extra compensation that B has to pay to C for breaching his contract with C, which he can also recover from A. So that becomes the substantial damages. Hopefully that cleared things up, and we're coming to the end of this video. Alright everyone, now that we've come to the end of this video, I really hope you understand the different types of damages and also the types of damages as under Section 73 of the Indian Contracts Act. So, I mean, without any means of compensating aggrieved party through damages, there would obviously be no point in having law governing contracts, right? What is the point of something if you don't have provisions to enable it? So section 73 to 75 of the Indian Contract Act deals with the consequences of the breach of contract. And it enables the aggrieved parties to claim compensation for the losses suffered by them. So section 73 specifically deals with unliquidated damages, those 6 types that I've told you. But liquidated damages, for example, are dealt with under section 74. And understanding types of damages is, of course, always the first step in empowering any person to entering into a contract. If you understand how you can recover damages, how you can get a compensation, you'd obviously be a lot more confident in entering into a contract in the first place and making sure that all your rights are taken care of. So that brings us to the end. Thank you so much for watching and have a great day ahead. Also, if you like this video, be sure to like and subscribe. And stay tuned because we have a lot more videos coming up. Thank you for watching.